Morning, everyone.
Oh, I can't hear you, Pat, if you're talking to us.
Can you hear me now?
That might be on
So
my.
if you can hear me, can you hear me?
Yeah, I can now.
Okay, excellent. All right. So apologies for having to come in through the Zoom, but I have car difficulties. So this was the only way for me to participate, unless I wanted to walk to Augusta, which wasn't going to happen. So I'm going to ask if somebody can take over the management of this meeting, because it's difficult for me where I'm the only one remote to be able to see everyone who's got questions. So can anybody volunteer to take over the management of this meeting?
Yeah, sorry, just trying to make you louder, Pat. It's not letting me.
Can you switch the speaker?
Well, that's a switch. No one's ever tried to make me louder before.
Well, now we'll try to turn it down.
Now we gotta make you quiet. All right. Brenda, did you hear what she said at the beginning?
That she wanted someone else to take over?
Yeah.
Yeah.
Yep.
Any volunteers?
How long are we scheduled for? Just to 11? I have a call at 11, that's all.
We're scheduled for 90 minutes, but only one thing on the agenda.
Okay.
So
There's only one thing on the agenda.
Yeah, my portion is, like, I plan to be very quick about it and then turn it over to questions.
Would Courtney or Betsy be willing to chair the meeting on behalf of Pat?
sure.
Thank you, Courtney.
I can do it, but I'm also doing this, and it's kind of hard to pay.
I'm happy to do it.
Thank you.
Thank you, Courtney. I appreciate it. Thank you.
Yeah.
Okay, great.
And as Brendan said, the only thing on this agenda is a conflict of interest. So thank you.
Okay, so good morning, everybody. I'm gonna call the meeting to order. This is the Governance Committee meeting of the Maine Recovery Council.
Eventually.
Should we start with just a quick round of introductions so anybody that's listening knows who's in the room? My name is Courtney Gary Allen, and I'll go to my right.
Betsy Fitzgerald.
Gordon Smith.
I'm Pat Kimball, and I'm on Zoom. And Eric, when I sent an email to him, it appears he's on vacation, so I don't think Eric will be attending today.
Eric's at a conference in Washington.
That's it. I knew there was something.
Wonderful, thanks, Pat. And then with the Attorney General's office?
Oh, I'm Haley Tranko with the Attorney General's office.
And I'm Brendan O'Neill with the Attorney General's office.
Wonderful, thank you so much. So the only thing on the agenda today is the conflict of interest policy, and I'll just turn it over to Brendan to give us a overview of where we're at and then open it up for questions and comments from the committee.
So as a refresher for really the public, the committee, the Recovery Council at its last meeting in early August, or maybe in July, had determined that the draft conflict of interest policy, which is meant to be a article in the council's bylaws, should first go to the governance committee for its review and any changes that it would recommend, and then the governance committee is to make a recommendation to the full council about the conflict of interest policy and any changes to the draft policy. On August 4th, I circulated to the members of the governance committee, which are Pat Kimball, Gordon Smith, Betsy Fitzgerald, Courtney Gary Allen, Eric Small, a copy of the draft conflict of interest policy, which is my proposal for the council. And so the document that we're going to be discussing today is the version that was circulated on August 4th. It's 4 pages, and I'm happy to go through it unless anybody wants to ask any questions at this point. Not hearing any. So I'm going to dive right into the draft conflict of interest policy, which is drafted as Article 9 of the council bylaws. There's three sections. Section 1 lays out the purpose of the conflict of interest policy. Section 2 is what I think of as sort of the operative guts of the conflict of interest policy. And Section 3, each of these 9.1, 9.2, 9.3, is a section dealing with a financial disclosure statement that the policy contemplates the council members filling out and submitting to the chair so that potential conflicts can be monitored. And just, I'm going to go first I'm going to not dwell on section 9.1. I think it's, it sort of is fairly straightforward, but I'm happy to answer questions about it. So I'll go straight into section 9.2 and just a brief tour of how the policy works. In subsection A1, that's the definition of conflict of interest. And it means, and this is largely borrowing from the conflict of interest policy that applies to the Efficiency Maine trustees, which is in Title 35A, Section 10107. It states that a conflict of interest for the council means receiving a direct personal benefit from the activities of the Recovery Council. That's one. Or the other one is, or serving as an owner, employee, contractor, volunteer, or board member for an organization applying for support from the council. And the way that really works is, if you go to paragraph C, paragraph C states that when a potential conflict of interest of either of a council member or the council member's spouse or dependent children has been identified by anybody, that could be by that council member or by another council member, it lays out kind of what happens at that point. The member is required to answer any questions from the full council regarding the nature of the potential conflict of interest and shall disclose all material facts. The purpose of that is so that the council can make a determination about whether there is in fact a conflict of interest. The next sentence in paragraph C sort of gives two avenues for going forward. The council member involved can elect to self-recuse from any further council activities regarding the potential conflict of interest. Or if the council member either doesn't or doesn't want to, the remaining members of the full council shall, by a vote, determine whether a conflict of interest exists. And so that's really the kind of where things happen. First, you identify, council members are encouraged to identify, encouraged in paragraph B, and I'll go back to that in a minute, are encouraged to identify potential conflicts of interest, whether they bring it up on their own or it's described in a financial disclosure statement under section 9.3, or if somebody else brings it up. It's meant to be identified, and when it's identified, for example, a council member says, I think I have a potential conflict of interest regarding this particular application, whether it's somebody applying for a grant or somebody applying to be awarded a contract to provide services to the council as a vendor. The council member is required to answer questions from the full council for the purpose of determining whether or not there actually is a conflict of interest. The two options in the next sentence of either self-recusal or the council by a vote determining whether a conflict of interest exists, what's going on there is, there's an interest in not gumming up the works of the council with lots of votes about having to have lots of votes about, conflicts of interest. Part of that is because, as described in both 9.1 and in 9.2B, this council is deliberately comprised of individuals who are deeply involved in the work that the council needs to do, needs to fund. And so that's, by, deliberately by design of the council in its organizing documents, that the expertise throughout Maine of people working on opioid use disorder and the opioid crisis, would find themselves on the council, and that automatically creates, or is almost certain to create, dual, situations of dual interest where council members have, interest in the council's activities, but they also have an interest in the activities of entities that could receive money from the council. And so the policy is intended to reflect that. So it's possible that there could be, a fair bit of activity around identifying conflicts of interest. Giving council members the opportunity to self-recuse was kind of a pressure valve that was intended to, eliminate the need for time-consuming deliberations by the council. There may be, if there's another way to do that, I think that's fine to consider. But the purpose there is to, the backstop is the council determines whether there's a conflict of interest. And it can do so and shall do so by a vote after hearing all the information about the potential conflict of interest. A way to speed things up is for council members to self-recuse.
Can we pause right there? Just
Yeah.
have two questions.
Sure.
The first question is under section 9.2A.
Yep.
Around volunteer being in that list. That
Yep.
seems like, for me, that just seems like a real stretch. I can think of about 20 different organizations that I volunteer for.
Yeah.
I'm just not sure. I just wanted to raise that, I volunteer for young people in recovery, but I have no financial obligation or interest in their getting of money, I guess.
I deliberately included, I sort of went back and forth on whether somebody could be a volunteer. And my recollection is, and I should have anticipated that question. Yeah, so it comes from the MEHAF conflict of interest policy. And I think about MEHAF, as I've described before, as an analog, an entity that we can look to for similar, as a similar entity that does similar work. It's a private foundation, as I understand it, that distributes grants to entities and well, let's just say entities around the state who work on public health issues, including the opioid crisis. And the conflict of interest policy that applies to the trustees of the MEHAF, MEHAF is the Maine Health Access Foundation.
Okay, I mean, that's fine.
I'm happy to.
It's not a
Yeah,
big thing for me. I just wanted to raise it as kind of a extensive part of the policy.
yeah. I can, provide, I'm sort of speeding through it right now to remind myself, but it's part of the grant making conflict that's part of the MEHAF policy, and the council doesn't have to follow what MEHAF does, but if you think about, there are circumstances when somebody's influence as a volunteer in a nonprofit organization or a private foundation, could inure to their personal benefit in terms of reputation, in terms of other opportunities in the future. And, or it could be seen as, if you're a volunteer board member of an organization, the organization's getting funding, and then, some of that funding is going to pay for that volunteer board member's friends or colleagues.
Yeah, that makes sense. I do not want to bog this policy down with that at all.
Yeah, it's a important question. And I'm simply describing to you my thought process. The council, you guys can think about it differently if you wish.
So if I'm not mistaken, if we use Courtney's example, Courtney, if we say some organization came up and Courtney would then say, you just need to know I'm self-disclosing that, a couple times a year I volunteer for this organization. Then it's really up to a vote of the council to say whether they think that's a conflict. Because there's a difference between what Courtney is saying, I'm an occasional volunteer, to if somebody's a board member on a nonprofit.
Yeah,
So,
that's
but
right.
it's really, if I'm reading this right, it's really the the board member, a member of the council, will self-disclose, and then the council takes a vote on whether they believe it's a conflict. Is that right?
That's right. And this is a good opportunity, Pat, to draw the committee's attention to paragraph B. So, section 9.1, I haven't dwelled on it, but it basically says the council's got an obligation to be transparent, and it has an obligation to, to put in place a conflict of interest policy. Paragraph B, 9.2B, sort of spells that out a little bit further, saying that the council shall endeavor to avoid both a conflict of interest as well as the appearance of a conflict of interest by disclosure and by abstention. The, members, sort of skipping down a bit in the paragraph, members must neither use nor appear to use their position for personal or professional gain or to promote the solicitations of their affiliated organizations. And then the next section sort of talks about the dual interest of the council members. Skipping down further, timely disclosure and candid discussions are critical to minimize the likelihood that a member's affiliation with other public, private, or governmental organizations will be perceived as conflicting or promoting undue influence. And I think, Pat, your point is, or maybe I'm piggybacking on your point. The goal of the conflict of interest policy is to get the information out there. And the council can then decide, after getting the further information described in paragraph C from the council member, whether there really is a conflict. They may say there isn't, and they may say they're fine with it. And the scenario you both are raising brings us to paragraph D, which is kind of where the rubber meets the road here. In terms of what a conflict of interest is. The first sentence says, a member or a spouse or dependent child may not solicit or receive any direct personal benefit from the activities of the council. The next sentence, however, says, but when there's a conflict of interest, say somebody's a volunteer, it does not prohibit entities for which a member is an employee, is an owner, employee, contractor, volunteer, or board member from participating in program activities if the member abstains from, voting on those kinds of activities. So, if somebody's a volunteer with an organization, they raise it to the council, they provide all the necessary information. The person can either self-recuse or the council can vote on whether it believes there's a conflict of interest there. If the council wants to, if the council votes that there is a conflict of interest, it can still go forward with that entity that the member is a volunteer for, so long as that member abstains from voting on matters relating to the entity's participation.
Great, thank you. Any other questions before Brendan keeps going?
Do you prefer to take questions, Brendan, as you go or after you get done?
As I go, that would be fun.
Have you,
For Haley just reminded me that for members of the public who are watching over Zoom, or well, we have copies here in person. For members of the public who are watching over Zoom, the document we're looking at is linked on the council's calendar page under under today's date. You can find a link for the document there.
My only question on 9.2 doesn't come up till paragraph C. Have you?
Paragraphs, yep, this is a good time for that.
Okay, so I only have two questions in the whole document. This is a kind of a technical one. The other one is more of a philosophical one, and it hasn't come up yet. I've always been a little confused in our bylaws about the quorum in 4.8 of the bylaws and the manner of acting, which is the 3/5 vote in 4.7. So when we say at the last paragraph, last sentence of C, we reference that if the council member is excused, then they're not to be counted in determining whether a quorum exists for the vote. Does that sufficiently, in your opinion, Brendan, cover us for 4.7 that we wouldn't, that the 3/5 vote, also the requirement of a 3/5 vote of those present in person or by remote method, that we would also be able to remove them from that count so that we wouldn't, so that it could affect whether we have to have 10 votes or 9.
So let me make sure, because I was flipping around a little bit, let me restate your question. If under 9.2C, the last sentence, if a member is not counted for determining whether quorum exists for the vote, and we look at section 4.7 of the bylaws that says of, well, 4.8 is quorum. Is your concern with 4.7 in the vote or 4.8 in the quorum?
No, I have no concern about 4.8 is quite clear.
Yeah. All right.
It's that I want the same rule to apply to 4.7, that which I guess we describe that as well, we could just, maybe it would be helpful to just reference 4.7, rather than describing. I mean, I'm just asking, I mean, I think the interpretation would be they're not counted for the quorum and they wouldn't be counted for under 4.7.
Right.
But we don't say that. And so, I mean, I'm basically saying from one lawyer to another, would it be helpful if we said should not be counted in determining whether a quorum exists for the vote, and would not be counted in any, under the provisions of section 4.7.
So just, first of all, I don't think I'm opposed to what you're suggesting. The only reason I might be is just for purposes of clarity, and it's always better for things to be more clear. So just looking at the last two sentences of paragraph C, 9.2C, if it is determined that there is a conflict of interest, the council member shall not be present during discussion or voting. And then further, the council member shall not be counted to determine whether a quorum exists for the vote. And so what you're saying may not be clear is what the 3/5 counts against.
Right, exactly.
So my read of this is that, at a council meeting, you discuss a conflict of interest. If it's determined there is a conflict, you subtract that council member at that meeting from the quorum and from the vote for the purposes of that portion of the meeting. That's how I had read that provision. And if and so you think you want to just reference section 4.7?
Well, I think you and I are interpreting it the same way, that they wouldn't impact on the quorum, and they also wouldn't impact on the 3/5 requirement. But we only reference in that sentence, the quorum. We don't reference the other odd requirement we have in the bylaws because we have to under the memorandum of understanding. So I think it would be helpful, I mean, given that, you know, I think it might be helpful to also reference not only 4.8, but also 4.7.
Do you have a suggestion?
Well, I'm thinking, and shall not be counted in determining whether a quorum exists for the vote or in any, or in determining the denominator of under 4.7 and in determining whether this vote has been achieved. You can do better than that. I'm sure.
So can I
Yes.
ask a question here? It has always been my understanding that to open a meeting and conduct business, you have to have a quorum.
Right.
But then if somebody gets up and leaves the room, the meeting still goes on because you achieved the quorum at the beginning of the meeting. So if you have somebody who it is determined has a conflict, it would be only that they did not participate in that part of the meeting. The quorum doesn't change. They're sitting there.
Doesn't it though? I mean, if somebody.
Well, that's why I'm asking.
I mean, so I think many of you have more experience in public meetings than I do. If a member of a particular body or multiple members get up and leave at some point, there's certainly quorum to start the meeting, but if
Right.
they leave partway through, I think my instinct, not based on anything other than that, would be that quorum is, the body no longer has quorum, or the quorum is affected by it.
Well, that's not how it works in the legislature. Like, they have to have quorum to open a public proceeding whatsoever. But then at that point, lawmakers can leave and come as they go, and as long as the chair is proceeding over the public hearing. I mean, I've seen 2 lawmakers in a public hearing at some point.
Right, I have too. Now, how about on city council?
We've never
been
in that situation, but I know we have come close to not meeting quorum to start the meeting, and had to call somebody in to meet quorum.
Yeah.
I think I hear Gordon saying, and let me try to reflect this back in non-lawyer speak. What I think I hear Gordon saying is that hypothetically, if there are 11 people present at a meeting and we open the meeting and one person has a conflict of interest and they step back from that particular part of the conversation and that particular vote, we lose one person. So we have 10 present members that have voting power. And therefore, we should only have to have 6 to pass something, because that is 3/5 of 10. Is that correct, Gordon?
Yeah, and I would also, I mean, it's good to think about a similar example on the quorum. There's 15 of us, so we have to have 8 of us to meet the quorum requirement, which is a majority. So one person excuses themselves, and that would give us 7. So if they were to be counted, we would lose the quorum. But because we've already stated in this draft that they wouldn't be counted, so we would still have 7 of, we would still have 14 of which, and we have 7, so we still have a quorum. So the person, it's like that person simply removed from the membership for the determination of those numerical findings. The same would apply to the quorum and to the 3/5 vote.
So in worst case scenario, we open a meeting with 8 people. One person has a conflict of interest, so there's 7 voting people. So we would need 4 people to vote in favor or against whatever it is before us to pass or defeat it. Correct?
Yeah, I'm not very good with fractions.
It's 4 point something, that's where we could get real weird. There was
It's the
one
4.
calculation I did that was like 5.4, and I'm like, is that 5 or is that 6?
More than 5.
2.3 children.
So it's more than 5, so it would be 6?
Yeah.
Okay.
That's what I would say.
Yeah.
So I guess I have 2 questions. So first of all, I had a different understanding of how I anticipate a quorum being considered. And I can see that I have borrowed this language from the MEHAP policy, which states, the affected individual at MEHAP, shall not, it's sort of verbatim, shall not exert personal influence to affect the MEHAP board's decision, and shall not be counted in determining whether a quorum exists for the vote. What's right for MEHAP may not be right for this council, and so there are those circumstances, as you've described, where quorum is a fixed point at the beginning of the meeting. I'm happy to take a recommendation to, it sounds like maybe you're suggesting that we strike that last clause about quorum, because maybe that doesn't necessarily make sense. My focus has been on voting. If getting into the mechanics of quorum is going to create a problem, I'm happy to between now and the full council meeting on the 14th, sort of reconsider that issue. As far as the quorum goes, on the voting, the scenario, had been, if you have 10 members present, one has a conflict, you take that one away, then you need 3/5 of not for a successful vote. So that's how I had been thinking about it.
Let me further complicate it by saying that I don't necessarily agree with the interpretation of how we achieve a continuing a quorum. The legislature operates by a different set of rules than Robert's Rules of Order, for instance. And I don't like, when you're spending millions of dollars, I don't like the specter that just because we started with a quorum and now half the people are gone, that 3 people are going to be taking votes. So that's a separate issue that's really not answered. And we can discuss that in front of the full council, how we could, because the members would get to decide how we choose to deal with that issue. I believe that under Robert's Rules of Order, for instance, that we don't reference in these bylaws, and I don't know if MEHAP does, that a quorum call, if nobody says anything, I think your interpretation is generally correct. But if somebody says, do we have a quorum? And you don't, then you're done for that meeting.
I think that's appropriate. I was not arguing
Yeah.
for any other version of the world.
So I wouldn't, we can talk about that, but I wouldn't dwell on that at this point. I'd focus on these. I would not want to take out this provision. In fact, I want to expand it to also reference the other 4.7. So what I'd suggest is maybe shall not be counted in determining whether a quorum exists for the vote, or in determining whether a 3/5 vote has been achieved pursuant to section 47 of the 4.7 of the bylaws.
I think the reference to 4.7, do you think that should, I mean, my suggestion is that would, belongs in the sentence before that.
Oh, I don't care where you put it, man.
Oh.
As long as it's there.
Okay. So, in the sentence before, and shall not vote on the matter, and what was your suggestion? And shall not vote on the matter or be counted for the purposes of section 4.7?
Yeah.
Yeah,
That's what he
that'd
said.
be okay.
Any other questions or thoughts? Does everybody on the committee agree with Gordon's suggestion?
Okay.
So if I understand it, Brendan, you're gonna redraft something there?
So I would add at the end of the second to last sentence of paragraph C, which reads, if it is determined that there is a
Yeah.
conflict of interest, the council member shall not be present during discussion about or voting on the grant distribution or contract, and shall not vote on the matter, and I will add, or be counted for the purposes of section 4.7 of these bylaws.
Okay.
It seems like everybody on the committee agrees.
Yes.
While we're on that sentence though, just like procedural, when it says shall not be present during discussions, are council members supposed to literally stand up and go out of the room?
You know, that would be my suggestion.
Okay.
So you know, in reading paragraph B, you know, shall neither use nor appear to use their position for personal or professional gain or to promote the solicitations of their affected organizations. You know, it's the purpose is to avoid promoting undue influence. In paragraph C, the first part of paragraph C envisions the discussion of whether there's a conflict of interest, and in that phase, the council member answers any questions once the conflict is disclosed, and shall disclose all material facts. At that point, and this is something the council could consider, or the committee could consider, at that point, there's sort of the path of either the individual member self-recuses or the council proceeds to a vote on whether there's a conflict of interest. Once there's a conflict of interest determined, my proposal is the council member leaves the room.
Okay,
And
that's fine.
but also is not present for any other council activity, whether it's at a committee or some other meeting about that application. It's, you know, it's worth considering whether it would be helpful to the council to have that person be present to answer like additional questions about the contract or, I don't know, the issue.
Okay. it seems
Okay, so we're all adults, number one. But number two, instead of get up and leave the room, which smacks of, I'm sorry, fourth grade, the affected council member leaves the table
Yeah.
and goes and
Yeah, yeah, yeah.
sits.
Mhm.
So they're still there.
Yeah.
But,
Yeah.
I mean, I
Yeah.
just think that leave
So-
the room is a little much.
So,
And we have some people on Zoom, like if they have to log right out of Zoom, it might mess everything. It seems
Good
like a lot
point.
to ask them to-
I just,
so the part of this paragraph I want to focus on about this is the last sentence. The affected council members shall not exert personal influence. And I think we've all seen circumstances where a person being present in the room can exert personal influence. Whether or not this group wants to have that be the way they, you know, something that they want to be concerned about. I mean, it's certainly something that has happened and it does happen. So I think this is an issue for the committee and for the council.
What if we were to say shall not participate during discussion or voting on the grant distribution, rather than say shall not be present?
So in that scenario, you've got a council member who's got a conflict of interest who is sitting next to you, you know, or sitting across the table from you, and that person stays in their seat but doesn't participate. I mean, again, I think it's for the council and the committee to determine whether that's sufficient for not exerting personal influence.
So,
Well, I think it's, go ahead, Pat.
so I sort of see this, if I'm thinking in regards to grants. So if the grant committee is literally discussing the application and scoring the application to proposal, I see that differently as someone sitting at the table when the final recommendation comes before the board. So for me, if we're reviewing actual applications, the committee is reviewing I think it's probably best that the person recluse themselves and not be part of the conversation. But I see it different, and I may be just looking at it differently, that if the grants committee scores the grants, brings the grants to the committee to discuss moving forward, I think that person, I don't have a problem with that person being in the room as the scoring has already taken place, and it's just a matter of discussing whether you're going to take the recommendation of what we saw. Is that making sense to people?
I think
But
you're kind of saying what I said better.
and again, I think there's no way you, and again, you may personally, I think we have to, and I know legally that's not right, but I think we have to respect people. For instance, I may determine I don't want to be in the room when this is discussed. It's way too close to me. So I'm going to, call me back in 10 minutes when you're finished the discussion. Or I may say, I'm just going to sit over here. I think it depends on the conversation and the in-depth subject we're talking. And that's a little hard to put in a rule.
I can see, like, just to kind of second what Brendan's saying, I can see in a hypothetical world where Chastity's organization, who I have a deep personal relationship with, and also the organization, if she has recused herself from a conversation and I have concerns about the application, it's gonna be real hard for me to raise my hand and say something negatively with Chastity, and I'm using this very like randomly, with Chastity sitting right next to me and these deep personal Maine connections to this organization and to the person sitting next to me. So I think I see where Brendan's coming from, that it might make it a little easier to raise my hand if Chastity was not in the room.
But these meetings are public.
True.
So if, and those are larger discussions we'll have, so if the grant process is public, then whatever you say is public anyways.
Yeah, that's true.
That's the whole. But we don't, again, we haven't got to the point whether scoring these grants is public or not. I mean, I don't know. So it's never simple.
What I could do is, let me just see.
But I like Gordon's wording, and I think that's sufficient enough until we come up with something that we hit a roadblock with.
So
I
let
have a
me,
question. Is this changeable?
yeah, this is a proposal.
Okay, could we possibly go forward with this for now? And if it becomes a really big problem, we'll come back to the governance committee and reconsider our decision?
I think particularly, Courtney, that I would agree with that. We may have to come back to it once we develop that process about grant proposals in scoring and awarding those.
And as the note in paragraph C indicates, again, this language I borrowed from the MEHAF policy. So in that case, the employees, the trustees, well, yeah, in that case, if you're working at MEHAF or if you're a trustee for MEHAF, you would not be present during voting on the grant or transaction and shall not vote on the matter.
Is MEHAF an open public meeting?
Do you know, Gordon, do you?
I would say no.
Yeah, I think that's the key difference here.
Mm-hmm.
If somebody leaves a board meeting at MEHAF, you're pretty much having what we would call an executive session, right? Without the person's not there, there's no public community conversation happening.
Right.
It's a private, quote unquote, conversation without the person. So I think that's the difference.
MEHAF is a little different, I think, in the sense that, first of all, I haven't looked into this, but I do wonder whether, they take minutes, and I wonder whether their meetings are something that the public can gain access to in terms of minutes, but also their organization, their structural organization is subject to oversight by the Attorney General's office.
Oh, okay.
Because of a consent judgment, as I understand. I wasn't involved, but as I understand it, it was created as an outcome from some sort of like hospital reorganization or something like that.
They were created by the
Yeah,
sale, when Blue Cross was sold to Anthem, and the value of the company had to be set aside in a trust. And that was created, that arrangement by the legislature. But it kind of sets it up, kind of like efficiency maintenance. It's kind of a quasi-public thing. Certainly, Attorney General's office has retains jurisdiction over a lot of it, but I don't know that I consider them, a public body when they sit together and make the grants, for instance.
So I'm wondering, for the purposes of, I think, this committee's desire to get this conflict of interest done, if we could accept Gordon's recommendation and kind of set aside this other conversation until it becomes a problem,
Gordon's recommendation being,
the change in,
Changing not being present to not participating. In that, it's about halfway on
yeah,
the next to last sentence in C. If it is determined that there is conflict of interest, the council member shall not participate, removing be present.
so certainly another option I can offer is I could, provide a draft that goes to the council that has both.
Both.
oh, that's a great idea.
Yeah,
And the decision will be made at the next council meeting?
Yep.
Okay, that's a great idea.
and then did we adopt my reference to 4.7 or not?
Oh, that's the one I was
That's what
saying,
we're talking
definitely adopt that.
Mhm.
Okay, so shall I read that again, what my suggestion?
Sure.
And starting at the end there, and shall not be counted in determining whether a quorum exists for the vote, or in determining whether a 3/5 vote has been achieved pursuant to section 4.7 of the bylaws.
So I had countered, I had offered a different suggestion, which is in the prior sentence, which is where we talk about voting, to end the sentence with, or be counted for the purposes of section 4.7 of these bylaws.
So it would come after that, and shall not vote on the matter.
Or be counted for the purposes of section 4.7 of these bylaws.
I'm fine with that. Okay,
I don't,
my colleague? Yeah.
we're wordsmithing,
That's good. Well, that's the
Legally.
nature of the Governance Committee.
yes.
Okay.
Okay.
Couple other things I want to highlight. I used, as you know, I've talked a lot about MEHAP here, but the other, as you know, sources of sort of guidance I used to develop this were statutes that apply in Maine to different entities, whether it's Efficiency Maine or executive employees, who distribute, funds throughout the state. And one of the important differences is that the statutes create consequences for individuals. This council doesn't have that authority to have consequences for individuals. So the bylaws basically take the stance that it describes what the council can do. And so starting with paragraph E, this is what happens when there's a conflict that isn't disclosed or that a person actively engages in participating in the council's activities. The council itself, we've already talked about what the individual's obligations are, disclosure and recusal. In the event that, to put some meat on the bones here, the council itself, however, is the one that's prohibited from entering into a contract with, making a distribution to, or expending recovery funds for the benefit of any entity if a member personally participates in his or her official capacity as a council member in any proceeding in which the member or their spouse or children have a conflict of interest, business partner of the member has a conflict of interest. There's paragraph 3 refers to prospective employment. Paragraph 4 is an organization in which the member has a direct personal interest, or somebody who's a shareholder in a professional service corporation. And so paragraph E says the council is prohibited from entering into a contract where there's that kind of personal interest, conflict of interest. Contrast that with where in the prior paragraph in D, where there's disclosure of a conflict of interest, where somebody is an owner, employee, contractor, volunteer, or board member, the council can go forward with engaging in activities with that entity so long as that member abstains from voting and otherwise participating. If there's a violation of subsection E, where the council has entered into a contract or other arrangement, and there has been a conflict of interest, it's the executive committee's job to further investigate that. And if the executive committee finds that there's a violation, the council shall immediately terminate any such grant, distribution, or contract and require the payee to return all unexpended payments. And the rest of that paragraph describes needing to include appropriate provisions in those forms of grant or contract. One of the complications here is, whether to apply the conflict of interest policy to vendors or contractors. It chose not to because it sort of made things a lot more complicated. If the council determines that there's a need to do that in the future, we can revisit this. But paragraph G basically is asking for disclosure also from applicants who are trying to get paid by the council. Paragraph H, talks about in-depth reporting in the minutes about conflicts of interest, with apologies to our secretary. And paragraph I, again, requires that contracts with vendors or contractors include provisions to avoid and remedy conflicts of interest between the council and the vendor or contractor.
I thought it was all fine. I struggled a little bit with, in the first paragraph of G, with the reference to former council members and what they could be constrained from doing or doing. But I think the reference to a direct personal benefit takes care of any concern I have. As an example, I think we each, under the MOU, we can each do two 3-year terms, maybe.
Two-year terms.
Two 2-year terms. So let's say I rotate off the council about the same time as I leave state service and go on the board at, say, Milestone or Wellspring, for instance. So I'd always be tagged as this former board, former council member. But they wouldn't, but again, if I was a board member, but not provided any payment. So essentially be a volunteer board member, then then they would actually wouldn't be required to identify that.
I'm not sure, I would need you to sort of restate that for me to be able to sort of weigh in on that, but let me just point out that G G simply requires applicants to identify when former members have the kind of described relationships with the applicants. It doesn't, that gives more information to the council about what it wants to do at that point. Doesn't prohibit the council from going forward. It's simply providing the council with more information about the relationship an applicant may have with a former member.
I think it's fine, but I just wanted to point out that it is limited to instances where the former council member is actually receiving a direct benefit from from that applicant.
Right.
So just for clarity, I work for a nonprofit organization 10 years from now. That nonprofit organization will put my name on their application and just say, Courtney is the blah, blah, blah.
Board member.
No, I'm working for this organization.
Oh, okay,
Like
yeah,
I'm the
yeah,
program director of Maine.
yeah,
Right.
And it's my paycheck.
yeah,
So they're gonna put my name on it and gonna say Courtney is a former board member of the Maine Recovery Council in 2023. She served 2 years. She now serves as the blah, blah, blah.
yeah,
Does that make sense?
yeah, yeah, I think that's right.
Okay. I think that's fine.
I do too, because I was thinking former council members, right now, we don't have any former ones.
Right, but we will.
I know, but
Yeah.
that's where my head went first, yeah.
Yeah.
You can imagine scenarios in which, for the public interest, there would be, entities that may have an interest in getting money from the council, can perceive to have some additional benefit from having former members in their organization. That they would be able to be more successful in helping them obtain council money. So.
But it's Maine, and that happens all the time. Maine's a small state, and so and there's a small expertise in regards to substance use disorder. So it happens. I think that, and I think I don't want to get into the depth of the conversation. I think that people are ethical and will disclose, but it's going to happen a lot because it's the nature of what it is. But I don't think people are doing unethical things, but you hire or you ask for volunteers to be on your board with an expertise. So why wouldn't you, if you were a nonprofit substance abuse agency, want a former member of the Maine Recovery Council on your board?
Okay, does the committee want to do anything about G, or is this just kind of a conversation that we're having?
I'm fine with it as directed.
I'm fine with G.
I do have a question about F,
Yep.
around the last sentence where it talks about the payee further agrees to return immediately all unexpended
Mhm.
payments from the Maine Recovery Council. What if there is no money left?
I think at that point, the council, could contemplate other steps such as like prohibiting further, contracts with this entity. Whether, I haven't gone down the road of, whether somebody could take action against the entity to return the funds, because it's something I'm happy to sort of think about, but I think it gets pretty complicated. There's no, effectively what would give rise to that would be a violation of the bylaws by a council member. Ideally, it would have been disclosed under G. But, and if it doesn't, maybe that gives rise to a claim of, fraud under a contract. The council, doesn't have the authority to bring that kind of a claim.
Who does? The Attorney General?
It's possible.
Okay.
But, that, I don't know that it needs to be written in that, again, this is the council's bylaws. So I don't know that it needs to be written into this document that that's the remedy. I think that remedy sort of probably exists out there at all times anyway with a contract.
That's fine with me. I just wanted to raise the question. Also, a hypothetical black hole that we don't need to go down.
Yeah, I mean, we could say nothing in these bylaws limits the ability of the Attorney General's office to bring further action against the payee. For instance, making them go back to where they've sent the money and collecting it, or prosecuting them for fraud. So, but I don't think we need to say it, because I don't think anything in the bylaws would be construed as being a limit on. And you'd hate to just mention the Attorney General's office, could be some other prosecutorial, could be a district attorney, could be.
Yeah.
That's fine.
All right, I'm hoping we can accelerate a little, just so the Department of Education isn't wildly upset that I don't join them at 11. How much more have you got?
I was only to briefly touch on the financial disclosure statements,
Sure.
but instead, I'm happy to just take questions on the financial disclosure statement or the provisions thereof.
I think it's fair. It's a little complicated in terms of what, once we get on an annual disclosure, right now, I would guess that the practice would be that as soon as the policy is done, people will be given X number of days to get in their financial disclosure. And then we proceed. I like the fact that if you haven't done your disclosure, you can't vote. We can't throw people off the council, because that can only be done under the MOU by the appointing authority. I'm not even sure about that. But so I like it. If there aren't questions, I'm going to move that we approve, that we recommend to the council at the next meeting the approval of the draft that we've gone through this morning.
I'm gonna second that in just 2 seconds. My only question was, in purposes of self-employment, is there a part of the form that requires a disclosure farther than just like the business entity in which you own? So who pays the business entity that you own?
Just turn to that part. It doesn't, I don't, just very briefly reviewing it again, it doesn't seem to require
Further.
who paid you.
Okay.
So the example listed on the second page of the form that I circulated, describes, Smith's Lumber Company, rough cut timber milling, doesn't require, or the next person, Robert Thompson, is the carpenter, doesn't seem to require you to describe who pays you.
Okay, all right, I'll second Gordon's motion.
Let's go, Jared.
Oh, a vote. Do we need a vote?
Yeah.
Okay.
Any more discussion?
Any more discussion?
Nope.
All in favor?
1, 2, 3, 4.
Anyone opposed? Abstaining? Okay. Motion passes.
So I do have a clarifying question for Brandon. This is an amendment to the bylaws, which means it doesn't have to have a public hearing. The council can vote on this at the next meeting if they choose to, right?
Yeah, let me just remind myself, turn to that section of the bylaws. Section 8.1.
Because we had to have a public hearing for the remote, but that was different.
That was,
that
that was because of
wasn't-
state law. That's
Okay.
because of state law.
Okay,
So here, under section 8.1 of the bylaws, they can be amended by the council at a meeting upon, a 3/5 vote. With the usual public notice that the council provides. And you can't violate state law.
Yeah.
So that's about it, yeah.
so we can
So-
just vote. We don't have to have the public hearing.
That's correct.
And in regards to the financial piece, we may have to do some helping people with that because that's not a norm. A lot of people on the board will not be used to filling out that kind of document to serve on a council. And so it just makes sure that they have plenty of days to do it and be able to know where to go to ask questions in regards to that.
That's fine. I think in terms of the timing, as chair, you can probably, have discretion about that, maybe in consultation with the other members for the first submission.
Okay.
And, we certainly will help in whatever way we can.
Okay. Thank you.
Okay, unless there's any further questions or comments, I think we could close the meeting of the governance committee.
So,
So, thank you, Courtney.
Welcome.
All right.
Pat, I'll give you a call.
Okey doke. I'm here at the lake.